Okay, today we have some folks from our own PUC office. Cynthia Lehman presently serves as mediation coordinator with the Office of the Administrative Law Judge in the PUC. She has been a mediator at PUC since 2008. Prior to that, she was in private practice with contracts in the U.S. Postal Service, the Pennsylvania Department of Education, the Multi-Door Resolution Program of D.C. Superior Court, and the World Bank. She was previously director of legal advocacy at the Epilepsy Foundation of America, and she's a longtime board member of the Pennsylvania Council of Mediators and currently is a member of the Advisory Committee on Alternative Dispute Resolution, the Joint State Government Commission. She received her BA from Eastern Mennonite College and her law degree from Antioch School of Law. We also have Tiffany Hunt. She's a mediator with the Office of the Administrative Law Judge. She previously worked as a special agent in the same office, and prior to joining the PUC, she worked for the Pennsylvania Liquor Control Board. Tiffany received her law degree from Temple University. So thank you for coming today to talk about the mediation program.
Thank you, Lori. So it's going to be interesting with the party downstairs, but we'll do our best to speak with you and talk to you about what we do and hear about what you do and answer any questions that you might have about the Small Business Mediation Program. I'm going to talk first just generally about mediation and our program in Office of Administrative Law Judge, and then we'll talk specifically about the Small Business Mediation Program. So mediation in general is a voluntary process where parties get together with a third party neutral, in this case that's Tiffany or me, and they talk about the issues that they have and hopefully come to some resolution that works for everybody. And so it gives them an opportunity to find their own solutions rather than having one of our administrative law judges handle the case and decide it for them. At the commission here, we use facilitative mediation, which means we don't give them advice and we don't tell them what we think would happen if they were going to go to hearing. Usually we have everybody in the room at the same time, and it works best in person. I mean, you can mediate over the phone, but if you have a lot of parties, it's difficult to do. So if possible, we mediate in person with everyone, and then if we need to, we'll break out and talk to parties separately as part of the mediation. So a mediation can involve just a few people, or it could be a whole room full of lawyers, engineers, accountants, and other professional people. Ideally, it's non-adversarial, but lawyers are used to playing a certain role and they can sort of jump out, try and be adversarial in the mediation. So there's always I need to sort of pull it back sometimes and remind everybody that it's a non-adversarial process. And the idea is that everyone can speak because it's confidential, and they're not bound by anything until they choose to be bound by it. They can basically throw out ideas and just have a free discussion. And whereas in a hearing, the lawyers would do most of the talking and guide everybody else through questions, in a mediation, everybody can talk back and forth. And I've had cases resolve mainly because the accountants could just talk accounting to each other and just get to it, get to the solution. Or engineers. I've had cases where the engineers were the solution. So it can be really helpful if everyone is on the page of trying to resolve a case to have a mediation rather than a hearing. Now, that's a big key, is that there has to be a good faith willingness to try and resolve, as opposed to using mediation just to get information or just going through the process. But we do our best to weed out the cases, so we only handle those where the parties are serious about moving forward through mediation. Mediation can deal with, we can come up with solutions that an administrative law judge could not order, and we can deal with issues that could not be handled in a hearing. So if the parties want to talk about non-jurisdictional issues, they can do that, and they can come up with solutions. If a piece of a case is something that the PUC doesn't normally handle, they can talk about that in mediation if they want to, and they can resolve that piece of the case. So there's a lot more flexibility in mediation than there is in the hearing. About 240 cases per year are resolved through the use of the mediation program. And these have included a variety of kinds of cases. Probably most of them are formal complaint cases, but there also are rate cases, motor vehicle cases, there was a cap rate design case a few years back, and other types of cases. And then in addition to what I've just been talking about, there is the small business mediation program, which is what we're really focusing on here. So the program was started in 2005 as a pilot, and at that time it really was just dealing with telecommunications issues. But the idea was to have a really quick, hopefully quick, and effective way for small businesses to find answers with the utility and not have to bring in a lawyer, because lawyers, as you know, are expensive. So this was the hope that it would be effective, and it was effective. So they moved it in, I think it was 2012, to include all fixed utilities that we have jurisdiction over. So since then, all small businesses could use it, and it has proven to be quick and effective for a way for small businesses to resolve their issues outside of the formal complaint process. And we found that most of these cases involve billing and security deposits. I mean, that's really the vast majority of them. So the process on our end is that if the small business chooses to send in a request to use the program, then I look them over and I see whether it's appropriate. And in a very small number of cases, I might decide it's not appropriate. Usually that's because they've also filed a formal complaint at the same time or beforehand, which we can't do them at the same time. If they have filed a formal complaint, it's just going to go forward on that route. Other times where I might find that it's not appropriate, if it's not really a small business, it's a larger industrial customer, or for one reason or another, it's just not a small business. Sometimes the charges that they're talking about happened more than 4 years ago, and in that case, we wouldn't accept it into the program. So if I don't accept it into the program, then I call up the small business owner or whoever filed on their behalf and just explain that they can go ahead and file a formal complaint if they want to. So once it's accepted into the small business mediation program, then we send out our forms to the utility, usually to a lawyer at the utility, asking if they are willing to use the program. And in most cases, they say yes. And in about 4 to 8 cases per year, they'll say no. And that's usually because they've dealt enough with this customer that they're not willing to bend over backwards to meet their needs. They just feel like it has to go through a formal route. So if the utility is willing to use the program, then we ask them to contact the customer directly and see if they can work it out. Usually it's the lawyer. Sometimes it's somebody else in the utility. And then the paperwork says that they're supposed to tell either Tiffany or I or me in 20 days, within 20 days, whether they were able to resolve the matter or not. And if it's not resolved, they have the opportunity, if they want, to have a mediation session, or they could just go the formal complaint route. And mediation is voluntary, so both sides would have to agree, to have mediation. So after 5 years now of having this program, we've seen certain patterns emerge, and I'll just tell you, I looked over some statistics in recent days, and I'll tell you what I've seen. So of the referrals that you all make to the small business mediation program, about 25% to 35% of those matters actually end up coming to us. They actually send in forms asking to use the program. And of those, I decide maybe 1 or 2 per year aren't really for the program. And about 4 to 8 cases, the utility will decide in a given year that they're not willing to use the program. But in cases where the utility is willing to use the program, about 73% to 81% resolve. And they usually do that pretty quickly, and they do that without us actually having a mediation session. So, and the reason I think that we don't usually go to have a mediation session is in these kinds of cases, it's pretty cut and dried. The customer knows what they want, they ask for it, the utility will weigh what they're willing to give, and there's really no room to roam there. It's either they'll do it or they won't. And so if they don't resolve, they have to go the formal route. Just looking at one particular year, for instance, as an example, in 2015, BCS sent out 170 forms. 40 of those came back to us with requests to use the program. The company declined to participate in 8, and 81% of the cases where the company did participate resolved. So it doesn't involve a lot of cases, but we find that when it is used, it has proven to be very effective and usually very fast. So now Tiffany's going to talk to you about with some more information.
Good morning, everyone. How are you today? Good. So Cindy just went over a lot of information, and the good news is that a lot of that is on the Commission's website. I didn't check to see if this computer was set up to the internet, but if you go to our homepage, you hit About PUC, and then you can select Bureaus and Offices. And once you do that, there will be a link to mediation. And you can select that link, and a lot of the information that Cindy just went over will be there. And let me grab my brochures. Prior to me joining the mediation group, Cindy and our previous mediation coordinator, Herb Nurek, put together a small business mediation brochure. And this is a great reference to use to not only refresh your memory, but you can also refer customers to this brochure, and it has our contact information as well. I printed out a few copies that I will give to Lori to take back to BCS, but please feel free to go to the website and pull this off of there and direct people to it. So I know that as investigators and interviewers, you cannot refer people or advise them or tell them that they should definitely use the small business mediation program, but I thought it would be helpful to kind of do a live infomercial and tell you about a few of our success stories so that you know it can work, and it can work well, and it can work quickly. So when customers are involved in this small business mediation program and they resolve their dispute, they don't have to tell us how they resolve the dispute. They don't have to tell us what they agreed to. They don't have to put anything in writing. They can simply say, it's been taken care of. But every once in a while, they do tell us. And so I want to just share a few of those examples with you guys today. So one small business customer alleged that for over a year, they had been paying for another customer's gas service. A meter had been associated with their account, and they had been paying, and so now they finally realize that they think they're paying charges that don't belong to them. And so they start with BCS, and BCS sends out the form, and they send it back in. We sent out the form to the utility company on January 8th, and on January 15th, so only a week goes by, the utility company notifies me that they've straightened out the accounts, they've straightened out the meters, and they've agreed to a financial settlement. So that only took 7 days. If that company had filed a formal complaint, it would have first gone to the Secretary's Bureau. The Secretary's Bureau has to serve it on the utility company. The utility company gets 20 days to answer it, and along with that answer, they can send in motions and preliminary objections, which are another part of the process. It's then scheduled for a hearing, and our hearings are set 4 to 6 weeks out. So then they show up at the hearing. They have to have an attorney there to direct their witnesses, to present exhibits. Then the judge has 90 days to issue a decision, which is appealable. They can file exceptions, reply exceptions. The commission can call it up on its own motion. So that process can take weeks, months, and in some cases years, and they were able to resolve it in a week. So it's a huge difference between going the small business route and the formal complaint route. And the companies are not precluded from then filing formal complaints if for any reason it's not resolved in the small business program. Cindy spoke about fixed utilities, but we've also had success with EGSs and NGSs. We had one small business customer request help with an early termination fee. They weren't disputing that they had to pay the fee, but they were disputing the amount, that it was going to be burdensome, that they couldn't afford it. So we send out our notice to the utility company. Again, a week later, the utility company notifies me that the parties had agreed to a substantial reduction in the early termination fee, and the matter has been taken care of. I don't know if you guys are following the Commission's case law on EGSs and NGSs, but it's still developing. And so there's no guarantee what would have happened with that had it gone the formal complaint route and a hearing, but a week goes by and they were able to take care of it. And then, as Cindy mentioned, the small business program and mediation in general really allows the parties to craft creative and flexible solutions to their problems. So we had another small business customer complain about a tariff change that had increased the monthly customer charge from $5 to about $75. That's a huge change. The company hadn't noticed it right away. The small business customer had not noticed it right away. They had paid for several bills, but now they're concerned. And so they contact BCS and they get to the small business mediation program. And the utility company says, look, we can't refund the money that you paid. We can't allow you to pay a discounted monthly charge. You know, this is the rate that's in our tariff. But what they did do is this small business customer is a volunteer group, and once a year they have a big fundraising fair. And so the utility company actually agreed to be a financial sponsor of their upcoming fair. That would have never happened if they had filed a formal complaint. Most likely, that formal complaint would have been dismissed on preliminary objections without the parties having any conversations with each other. So, you know, the small business route can work quickly. All of those cases were done in about a week. And they can be very successful. And the great thing about filing a small business request for mediation is it gives you access to the same people at the utility companies that handle the formal complaints. So it's the same attorneys, the same representatives that would handle your formal complaint, handle your small business request for mediation. You know, the cases that don't resolve, a lot of them don't end up going the formal complaint route. And I think that's because they're able to get enough information to decide whether or not it's worth it. So even if they don't get the resolution they're looking for from the utility company, they're still able to share information and they're able to have a discussion. And I think in a lot of cases, they decide the expense of an attorney and the time of a formal complaint process is not worth it. And that's a savings to them as well, to be able to figure that out for free versus figuring that out after having retained an attorney. So those are some of our success cases. Those are some examples of how well the process can work. You know, I've only been with mediation for about 2 years, and well over 80% of my small business cases are resolved. And they're done so very efficiently, and we've had really good feedback from people who have used the program. And so I think that's it for our overview, and we can take questions if you guys have them. I'm just going to pass some of these brochures out so you guys can look at them.
So does anybody have any questions? Yeah, back there. Oh, I'm supposed to give you a mic. Oh, she has a mic. Good.
Good morning.
Hi.
I'm curious to know, do you get many telephone mediation requests, telephone company?
You know, I don't, in small business format, no,
Mhm.
no.
No? Okay.
In the other formats, yes.
Thank you.
I mean, let me ask Stephanie, do you get many phone small business? No, okay. Anybody else have any questions?
Can you talk about what happens if they send out forms for formal and informal, and someone would fill out both forms and send them back in? Can you talk about what happens at that point?
Well, first of all, we hope that we figure that out. But
I
if
think
we
so,
do,
because there was an email that went out, but I just thought it would be
Yeah.
good for you to mention that.
yeah, if we happen to figure that, to see that or know that for some reason, and we don't always know that because the formal complaint process is so much slower that they might fill it out. It may not even show up on, you know, so that we know about it for several weeks. But when we do know about it, they'll just have to go the formal route. We can't handle it through the small business route because the formal takes precedence. Anything else? Yeah.
You may have answered this, and I apologize, but when a small business, if I'm talking to the small business owner, and I tell you, yeah, at the informal complaint level, we don't have authority over this, but you may want to consider filing a formal or filing for mediation. And immediately it's like, well, what does that entail? And I said, well, you fill out the forms, I'll mail it to you. At that point, somebody from here is contacting this business owner, right? I mean, they're going to pick up the phone and call them, or what happens?
Oh, so what does that entail? Would mean they would just send in the form, and then what happens is the next step is that we send out paperwork, which they will receive, which is directed to the company to say, are you willing to use the program? So within a week or so of us getting the form, hopefully sooner, they'll see this paperwork. And then the company, if they agree, will be contacting them fairly shortly to try and work it out. That's what happens. Now, if the company doesn't agree, it may take a little longer for them to tell me that. But once we know that, then we send out a form to the complainant saying, we can't use this process because it's voluntary and the company doesn't agree to.
Assuming they agree,
Yeah.
is anybody from the PUC contacting the business owner saying, hey, meet us on such and such a date downtown Harrisburg I'm still
No.
missing. If
No,
they
we
agreed
don't-
to work it out,
We don't have to do that. That would be more of a mediation, but we don't need to do that in these cases because of the process is set up for the first step is the parties to try and resolve it themselves. So they will hear directly from the company. And in most cases, that's effective. They and the company will have a discussion which will result in the case being resolved.
okay, just
Okay.
bear with me here. So
Tiffany, what-
I thought that we were going to have like a group of people all in one room talking things out. When does that happen?
All right, so I was not clear, I guess, in explaining that that is a mediation session, which we do.
Right.
We don't do that in small business cases because we don't have to, because they are able to be resolved by the parties themselves without a mediation. But I use that as an example because it's called the Small Business Mediation Program, and so you might wonder, well, what is mediation? And mediation is something that we do, but we do it more in the context of other cases that I talked about earlier, like the formal complaint cases, rate cases, cap design case, that kind of thing.
So I'm a small business owner. I contacted BCS, found out that, all right, they couldn't get it resolved. I'm going to file for mediation. Then this is, if I'm to understand correctly, they're not coming downtown here. So this is all going to be outside.
Over the phone.
Over
Yeah.
the phone.
Yeah, why don't you answer some questions?
Well, I'd probably just give up at that point because I've already been talking to the utility multiple times. I wouldn't even bother.
Normally what happens is they get a notice, and the notice is Cindy or it's me directing the utility company to contact them. And so they're going to get a phone call from someone from the utility company hoping to resolve the issue. And if for whatever reason the utility company can't get a hold of them, so maybe they say, you know, I've already spoken to the utility company, I don't want to do this anymore, then Cindy or I will reach out to them and we'll say, you know, we received a small business request for mediation form from you. The utility company is willing to work with you on this issue. We want to put you guys together on a phone call so that you can try to work it out.
We do get involved sometimes in different ways.
But we don't get involved unless they send the form back. And, you know, Cindy gave some statistics about the number of forms that BCS sends out, and we get back, you know, a pretty small number of those. And so we don't get involved with any customer who doesn't actually complete the form and mail back the completed form.
I think whenever we spoke earlier, maybe this would clarify some of it for Frank also. I think when they do get the notice from you, a lot of times the utility company, they know they don't want to come in for a formal case. So they want to try really hard to work it out with the customer in advance of having to come in for a formal case. So they elevate the concern, right? So they wouldn't necessarily be speaking to someone that they would just, you know, their customer service representative. They're probably going to be speaking with an attorney at that point.
Right.
Correct.
Right.
So I think that's how it's resolved. A lot of times they know that if it's not resolved in mediation, they're going to be looking at a formal case. And so the utility company really wants to resolve it so they don't have the expense of the formal cases.
Right.
I had assumed the filing of the informal would have accomplished that. And then we've got this next step up, and then you hit the formal. And I don't know. I guess the
Well, and-
informal complaint process hopefully would have worked. I don't know.
You know, sometimes you have
I'm
to go
good.
down the road, and as you go down the road of processing a case and different people get involved, and the utility companies have different discretion as the matter advances. And so what the utility company may have been willing to offer at the informal complaint level can be different than what they're willing to offer once a small business request for mediation has been filed. And that can even be different than what they're willing to offer once a formal complaint is filed. And so it's an ongoing negotiation. And so it's not just a repeat of what you did at the informal complaint process, because it's new people, it can be new information, and there are different forces acting upon the parties to reach a resolution. Does that make sense?
Yes.
Okay.
I just want to say, if you talk to folks, if you think of it, remind them when they send in the form to us, they should put the full information on the envelope, which is mediation coordinator, OALJ, PUC, and the address. Sometimes they just say the address or mediation coordinator and the address, and they can go around the commission for a month and before if they come to us. So it is important they put all that information on the envelope. Yeah. I feel like we should sing.
Okay. I'm impressed with the resolution numbers, and I'm surprised at the low number of requests for mediation. And in my opinion, I think you might see an uptick in the number of businesses that apply for mediation if you include those stats in that brochure, because they are impressive.
Yeah, if they're not in there, you're right. We should put them in there. Yeah.
Okay.
Okay. I think it's enough with the music. Oh, go ahead. How often? Is that what the question?
How often do you get the mediation, the small business mediation request when it comes to suppliers?
I don't get that many, but you get quite a few. So somewhere in between.
I would say the majority are from the electric distribution companies, but just kind of off the top of my head, I would say, you know, maybe 3/4 are from the EDCs and the natural gas companies, and then the remaining quarter are from the EGSs, because people, you know, just like residential customers were signing these contracts and the polar vortex was hitting and they were trying to switch. And so they had a lot of the same issues that the residential customers had. And go ahead. I have found that the EGSs and the NGSs are responsive. They're not always able to resolve them, but they will, you know, follow up with them, and they will have a conversation with them about, you know, their dispute.
And I would just say I find that they don't settle as often as the other cases. And I think that's because the other cases have experienced attorneys who know the land and can make decisions that the EGS, they just don't have the experience with us, or they're not even an attorney dealing with it. It's just different. Okay. All right. Well, thank you all.